Hello and welcome to Topic 12, Lecture 1, last topic of the semester. And in this lecture, we're going to take a look at the right to counsel. Okay, as I'm always telling my students, criminal proceedings are state versus individual. And the state is mighty, the individual is less mighty, particularly in matters dealing with criminal justice. And so, as we know from last week, that the Bill of Rights limits how a government can make a case against the individual. And so last week, we were learning about the state trying to collect evidence and investigate people for crimes and the role that the Fourth and Fifth Amendment play in limiting the power of the government in engaging in evidence and investigation. Not just limiting the government, but making sure that the government investigates and collects evidence in a way that doesn't violate the rights of the individual, that doesn't violate the due process of law. Once charges are leveled against an individual, the Bill of Rights provides protections for individuals that are charged with a crime. And so the evidence and investigation is trying to come up with enough probable cause to say that this person should be arrested and charged with a crime. And once a person is charged, the Bill of Rights provides protection for individuals moving forward, sort of trying to balance the scales of justice between the state and the individual. And so in this topic, we're going to be taking a look at the Sixth and the Eighth Amendment. And in this lecture, we're going to be looking at the Sixth Amendment, in particular, the right to counsel. So here is the language of the Sixth Amendment. We'll go ahead and read the entire Sixth Amendment. It's important. There are a lot of trial rights that are in the Sixth Amendment, and we're going to be focusing on the right to counsel. And in course commentary, I'll be writing about the other trial rights that your textbook talks about. So the Sixth Amendment reads, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in their favor, and to have the assistance of counsel. So there's a lot going on in the Sixth Amendment. The Sixth Amendment is basically saying that you have a right to a speedy and public trial. So you're going to be reading in the textbook about what constitutes a speedy trial and to what degree trials need to be public. You're going to be learning about how juries are selected, and that when you say an impartial jury, how do we go about ascertaining? How do we come about actually impaneling an impartial jury? And then you're also going to be that you need to be informed of the nature and cause of your accusation, and that's what takes place in the arraignment, where you're told what you're being charged with. And then in trial, you have the right to confront witnesses against you. So if the state is bringing witnesses to prosecute or to testify against you, you have a right to cross-examine them and cross-examine them in person. You have the right to bring your own witness, and that's what it means to have compulsory process for obtaining witnesses in your favor. So the defendant can subpoena people to come and testify in their favor. And as we're going to be talking about in this lecture, that you have the right to assistance of counsel for your defense. All right, so let's take a look at the assistance of counsel. So early on in our nation's history, the right to counsel was regarded as sort of an uncomplicated matter. Most people handled their own cases, and there were few lawyers that would come and be present in the court. But as the nation develops and as more laws are created, there's more need for lawyers, and because the law and the charges against you become more complicated. Initially, the right to counsel was defined by the court as a thou shalt not on government. In other words, the right to counsel was basically telling the state that it's forbidden from preventing you from having legal counsel. If you want legal counsel, you can have it. The state can't tell you get rid of your defense counsel. You have to pay for it. You have to provide it. There was no obligation for the state to provide you with counsel. The thinking about the right to counsel changes as we enter into the 20th century. It's a right, and that as if this is a right, you should be able to exercise this right. I mean, if the only way you can, if the Sixth Amendment only means that the state can't tell you to get rid of your defense attorney, well, a lot of people can't afford a defense attorney. So it kind of really dilutes the meaning of the Sixth Amendment. And so particularly in cases where there's a serious outcome if found guilty, that you should be able to exercise that right. And if you're not able to exercise that right due to finances because you are poor, indigent, then the state has an obligation to help you realize that right. In particular, since this has to do not just with the right of counsel, but really it's fundamental to due process, making sure that when people are tried and convicted, that they have been given a fair and reasonable treatment during that process. So the first case that we're going to be looking at with the right to counsel is Powell versus Alabama. It's also known as the Scottsboro Boys case. It's from 1932. It's historically a very important case, not just because of the way the court rules regarding the right to counsel, but it's historically important because it also kind of exemplifies the lack of due process and fair treatment that African Americans received in the early part and the mid part, and today as well, received in terms of criminal justice. So Powell versus Alabama is the first case to explore the question regarding the right to counsel in any sort of meaningful way. And keep in mind that Powell v. Alabama deals with a certain kind of defendant and a certain type of charge or penalty. So let's look at the facts of the case. So let's look at the facts of the case in Powell v. Alabama. So Powell v. Alabama, it's also known as the Scottsboro Boys trial or case. This is a case about many things. It's about the right to counsel, but it's also about racism and racial tensions and the sort of terrorizing circumstances that African American men faced at this time period in our nation's history. So the Scottsboro Boys case is about 9 young men who were riding an open freight car from Tennessee headed towards Alabama. And on the freight car were the Scottsboro Boys, but there were also a group of 9 white kids as well. 7 white boys and 2 white girls. A fight breaks out on the train car, and the white kids get pushed off of the train car by the Scottsboro Boys, and that the girls claimed that the black boys had raped them. Okay, and so they're off the train, and this rumor is spreading that the girls had been raped. Accusations of rape of black men, of white women, was a commonplace at this time period. So rumor spreads that that's what happened, and as the African American boys and young men, they ranged in age from 12 to 20, were heading into Alabama, that there was a sheriff's posse waiting for them there, took them off the train, brought them into Scottsboro, Alabama, which was the county seat. That there was an angry racist mob waiting for them. There was extra security as they were waiting in jail because they feared that the boys were going to be taken out of jail and lynched. The next day they were brought to the courthouse and they were charged with rape, which at that time period was a capital offense. And then because they were charged with the capital offense, that Alabama state law said that they must that if they can't afford an attorney, which they couldn't, that the state of Alabama must provide them with an attorney. So what the judge did is, rather than appointing a specific attorney to provide defense for the charged individuals, he appointed the whole of any person in Alabama who had a law degree. he appointed them, who had passed the bar, he appointed them as counsel, but nobody stepped forward to serve as their attorney. As your textbook points out, a lawyer from Tennessee who was concerned about the plight of these young men, stepped forward to provide defense. He didn't know any Alabama law because he was from Tennessee. He's assisted by another Alabaman lawyer, and that when the boys come into court and they're clearly scared, they're charged with the offense of rape, and then the trial is set 6 days from that point. It almost goes without saying that they were tried, and 8 of the 9 individuals were convicted of rape, and they were sentenced to death. So the question in this case is, were the Scottsboro boys' Sixth Amendment right to counsel, was that violated? So the question before the court in Powell v. Alabama is, do indigents have the right to counsel in a capital case? And in a 7-2 decision, the Supreme Court ruled that yes, in capital offenses, the indigent, those people who are too poor to have their own counsel, that they have a right to counsel and that the state needs to provide it. The reasoning offered by Justice Sutherland says that the defendant should have a fair opportunity to secure counsel. That did not happen in this case. The defendants here did not have aid of counsel in any real sense. The failure to give counsel in this case denied the boys due process, and they said that the court said that they were not deciding whether the Sixth Amendment right to counsel pertains to all criminal prosecutions, only in certain circumstances: capital offenses, public pressure, young, uneducated, and inexperienced defendants. Okay, so they're sort of limited in their reasoning. The dissent, Butler, said that the defendants actually did have counsel from Tennessee, and if they needed more time to prepare, they should have asked for it. They didn't, so their due process rights weren't violated because they actually had counsel. Their counsel just didn't do a very good job. So what are the takeaways from Powell? Well, the decision in Powell was limited. It says that yes, counsel must be appointed in cases with unusual circumstances, and that mandated counsel in these sorts of instances, so that the Scottsboro boys were, as a result of this, given counsel, but you can see that, as your textbook points out, there's very limited impact for the defendants in this specific case. And so make sure you take a look at page 541 in your textbook to you basically see what those, the sad sort of outcome for many of the Scottsboro boys was. However, it doesn't answer the question as to whether every defendant has a right to counsel. In this, it says that people who are facing a capital offense have a right to counsel. If somebody's uneducated, they might have a right to counsel, right? Extreme circumstances, you might have a right to counsel. But it doesn't do a good job of sort of like defining the right to counsel broadly. So it didn't answer the question as to whether every defendant has the right to counsel. And that question is answered in the landmark case, Gideon. Now, before we talk about Gideon, I want to draw your attention to the table that's in your textbook that's comparing the way the court has dealt with the exclusionary rule, comparing that to how the court has handed the right to counsel for indigents, those who cannot afford a right to counsel. Now, to recall, the exclusionary rule is basically saying that if a search is illegal, the contraband or whatever is found during that illegal search, that it cannot be admitted in court. It's inadmissible. That's what the exclusionary rule. If it's an illegal search, the product of the illegal search is inadmissible. And you'll note that when it comes to the exclusionary rule, that the court took a very specific sort of path. Initially, they said that the exclusionary rule, and very early on in 1918, said that the exclusionary rule applied, but only when the federal government was prosecuting you. So if the federal government engaged in an illegal search, then that evidence collected in the illegal search could not be admissible in the court. But then in Wolf v. Colorado, that question comes to the court in 1949 about whether or not the exclusionary rule applies to the states. And in Wolf v. Colorado, they said no. It only applies to the actions of federal prosecutors or federal law enforcement, right? That a federal case, it applies, that provision of the Fourth Amendment applies, but it doesn't apply to state actions. So if states engage in illegal searches, then that evidence can be used in court. But then the court changes their track, and that they basically, 20 plus years later, in Mapp v. Ohio, they apply the exclusionary rule to the states. The same trajectory takes place with the right to counsel, okay? So in Johnson case in 1938, the Supreme Court said that everybody who's facing a federal prosecution has a right to counsel. The question about whether or not the right to counsel provision of the Sixth Amendment applies to the states comes to the court in the 1940s in Betts v. Brady, and the Supreme Court says, nope, it doesn't apply to the states. But then in Gideon versus Wainwright in the early 1960s, they change course and they say, oh wait, the right to counsel does apply to the states. I think that, when trying to find out a reason why that is, it could very well be the court's understanding of the role of states. So because of the 10th Amendment, that police powers are reserved to the states, and the vast majority of criminal prosecutions and trials take place at the state level. And so there might have just been a hesitancy for the court to interfere with federalism, right? It's sort of like, we'll say that the Sixth Amendment and the Fourth Amendment apply to the actions of the federal government, but we don't really want to extend that to the states, because states can kind of make their own decisions about whether or not they want to employ the exclusionary rule or whether they want to employ a right to counsel. But then in the 1960s, under the Warren Court, there is a more progressive understanding of the robustness or the need for a robust application of the Fourth Amendment and the Sixth Amendment to the states. So it's interesting to see sort of a similar approach taken by the court in both the exclusionary rule and the right to counsel. So this is just a summary of what I talked about a written sort of overview of what I talked about on the last slide. So in Johnston v. Zerberst, 1938, the question came before the court about whether or not indigent defendants deserve to have counsel in all kinds of cases, whether they're capital cases or not, whether or not the defendant is illiterate or not, or whether there's special circumstances. And they basically said in all federal cases, the federal government must provide defense for all defendants. Okay, so indigent defendants are entitled to counsel in all federal cases. That question comes to the court as it applies to states in 1942. And so in this case, you'll read about it in your textbook, that Smith Batts, he's charged with robbery. He's poor, white, uneducated, but he's literate. Okay, so you can, he's uneducated, but he's a smart guy. He asks the government for a lawyer. This is a state offense. He's denied. They say that the state only provides for a defense in murder and rape charges, capital offenses. He represented himself. He was found guilty and he appeals. And in that case, the Supreme Court says, no, states can decide whether or not the extent that they want to enforce or apply the right to counsel. If states want to say everybody gets the right to counsel, they can do it, but there's no constitutional mandate for states to do that. And so the question is, should Johnson apply to the states? And that's the question that comes to the court in Betts v. Johnson. So does Johnson, that everybody gets a right to, all indigents get a right to counsel, does that apply to the states? And they said in the 6-3 decision, it does not. They said that the right to counsel is not a fundamental right. And Betts was not like the Scottsboro defendants, that the Scottsboro defendants, there was racial hostility, they were illiterate, they were scared, they were facing a capital offense, and they said that Betts does not rise to the right to counsel that is established in the Scottsboro case. And so it's in Gideon where this question comes to the court again as to whether or not Johnson applies to the states. In other words, whether Betts v. Brady should be overruled. So Gideon versus Wainwright is very similar to the facts of the case in Betts. And just for the pictures here, here's Gideon, Clarence Gideon. And as you read in your textbook that he was denied the right to counsel. He was charged with breaking into a pool hall in Florida that the trial court refused to appoint him counsel because Florida only provided counsel for people who were charged with the capital offense. Breaking into a pool hall in Florida, surprisingly, is not a capital offense, just joking. Clarence Gideon was like Betts. He was poor, uneducated, but he was literate, and he tried to defend himself without a lawyer, and he was failed to do that successfully, and he was found guilty. As you read in your textbook, when he was in jail, he learned the law, and or when he was in prison, he learned the law, and he submits a brief to the Supreme Court, what's known as a pauperous brief, because he was a pauper, he was poor, and the Supreme Court allows for that, as you know, that when you are applying to the Supreme Court for a review, there's a certain format you're supposed to follow, but they allow for what's known as informa pauperis request for review. And Clarence Gideon famously writes his request for a writ of certiorari on prison notebook paper, and the request for review is granted. So the facts of the case are very simple. Breaks into a pool hall, isn't provided counsel because Florida only gives counsel to people who are accused of capital offenses, and then while in prison, he requests the Supreme Court to review his case because he says his Sixth Amendment rights to counsel were violated. So the question before the court in Gideon versus Wainwright is, should the court holding in Betts be reconsidered? In other words, should the right to counsel for all indigent defendants apply to the states? And in a 9-0 decision, the court said yes, that they're going to overrule Betts. Note that Justice Hugo Black is the one who writes the opinion of the court, and you'll note that he had the major dissent in the Betts case. So again, you have a dissent that then flourishes and becomes a majority opinion in the future. We've seen that throughout the course of the semester. They argue that the court argues that the right to counsel is a fundamental right and thus should be incorporated to the states. Betts was wrongly decided because it did not fully consider the court's precedent in Powell. They said that looking at polling jurisdictions, 22 states agree that the right to counsel should apply to the states. You'll note in your textbook that an amicus curiae brief was that represented the viewpoint of 22 states in the United States, was written by Walter Mondale, who just recently died. He was the Attorney General of the state of Minnesota. And the claim that counsel is a fundamental right is supported by the fact that the state spends a lot of money on the trial, and so do defendants if they're able to, right? And so if you have the money, you're going to make sure that you lawyer up. And so clearly the actions of defendants, if they have the money, indicate that right to counsel is fundamental. And that same right should apply to the indigent, the poor, those who cannot afford an attorney. So why is Gideon important? Well, Gideon is important because it's an example of the Warren Court's revolution in criminal rights. It shows the importance of the dissent. The Hugo Black dissent in Betts becomes the basis of court opinion in Gideon. it has a huge impact on the criminal justice system. 80 to 90% of those who are accused of crime are eligible for indigent defense, where the state must provide them with public defenders. And so the state becomes responsible for providing lawyers for the accused. Now, my criminal justice class, and for those of you who are in this class and my criminal justice class, we can sort of see the overlap here, right? That yes, you have this right, but we also know that public defenders are underfunded and they're not funded well enough in order to stand up to the state. So while this is a first good step, there's still a lot of work to be done in making sure that those who can't afford an attorney get adequate and excellent defense. It improves the status of criminal defense lawyers. It used to be seen as sort of dirty business to be a criminal defense lawyer, but now that it's seen as a constitutional right, more young lawyers coming out of law school are, to this day, step up to the plate and say that our Constitution doesn't mean anything, the Bill of Rights doesn't mean anything, the Sixth Amendment doesn't mean anything unless those who are poor also get excellent defense, right? And so it kind of increased the sort of constitutional incentives to participate in criminal defense. It's also, there are unique characteristics of the case. As I mentioned, the writ of certiorari, the request for certiorari is submitted in form of papyrus, and also a future Supreme Court justice represents Gideon at trial or at the Supreme Court, Abe Fortas. And so it's a landmark case for a wide variety of reasons. So coming out of Gideon, questions remain. The main question is, do all charges, are all charges covered by Gideon? And your textbook talks about that if a person is charged with a crime and there is a possibility that if they're convicted of that crime, that they will lose their liberty. It's called the loss of liberty rule, that a punishment could be 1 hour behind bars. Then you have a right to counsel. So if upon conviction you can be incarcerated even for 1 day, you have a right to counsel. And so that covers a lot, almost all charges, right? I mean, misdemeanors, there are very few crimes that you commit that would not potentially result in a loss of liberty if you were convicted. Now, traffic ordinance violations and those sorts of things, you don't have a right to counsel, because if you're convicted of violating traffic laws, you ain't going to jail. But for the vast majority of criminal violations, you have a right to counsel. And you can't be sentenced to incarceration if you didn't have counsel. And so that's sort of a way of ensuring that people got a right to counsel, because if you're convicted and you didn't have counsel, well, you can't be sentenced to loss of liberty. It applies to suspended cases and juvenile cases, so it's very robust. You'll be reading about this in your textbook. And so a case comes to the Supreme Court where a person gets a sentence of 1 year, but then it's a suspended sentence. It's basically saying, well, if you live up to your terms of probation, then your sentence will be suspended. You won't have to serve your sentence. But if you don't live up to probation, then you have to serve your sentence. Do you get a right to counsel? Yes, even with suspended sentences, and juveniles have a right to counsel as well. How far does the right extend? Well, we learn in the textbook that you have a right to counsel starting at the point of interrogation and extends all the way through the first appeal. After that, it's up to the state. Okay, so you got one appeal, you have the right to counsel. If you're going to appeal, again, depends on the state laws. You don't have a constitutional right. Must counsel be effective? Yes. You'll read in the textbook about how defective counsel is defined in Strickland v. Washington. That basically they say that the errors that the counsel made are so serious that the counsel was not functioning as counsel, and that the counsel's errors were so deficient that it deprived the person of a fair trial. Okay, so you can't just give anybody a defense attorney and say, giddy up, you've got right to counsel. Your right to counsel actually has to be effective. And just in defense of public defenders are by and large, excellent counsel, right? They may be overworked and they may be really stretched thin, but they are effective counsel given the parameters of their job. Okay, that's it for the right to counsel. And the next lecture, the last lecture of the semester, am I going to get it done tonight? I hope so. The Eighth Amendment and the death penalty. Talk to you again soon.